Thank you.
Good morning, sir. Are you Moses Jones Jr.?
Yes, ma'am. Good morning, Your Honor.
Good morning. And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Jones, in cause number 25 DCCR 0848, the state has elected to proceed. Can you hear me? You're having a hard time? Is that better?
Yeah, one there.
Is it better now?
Yes, ma'am.
All right. So in cause number 25 DCCR 0848, the state has elected to proceed on the lesser offense of a Class A misdemeanor assault family violence from June 15th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with in that lesser offense?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And this is where people underestimate misdemeanor cases. Family violence, even at the misdemeanor level, triggers permanent firearm restrictions under federal law. No jury, no trial, just a plea, and a right you may never get back. This is the kind of consequence that doesn't feel real until it suddenly is. Did you expect a misdemeanor to carry this much weight?
Are you a U.S. citizen?
Yes.
State tenders number
No
1.
objection?
It's admitted. Is any evidence that Mr. Moses is not competent?
No, Your Honor.
All right, Mr. Moses, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor, assault family violence. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody.
3 months.
You'll get all that credit. You'll get all the credit that the law gives you the right to receive. And I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. There are some rules with regard to that because it is a family violence assault, even though it's a misdemeanor. So if you have any questions about that, you can talk with Mr. Parker. Read that document I gave you. It will also explain to you all of the factors that go into your ineligibility to possess a firearm or ammunition. Because if you do possess one and you're not supposed to, then it could lead to further charges. Do you understand? All right, good luck to you, sir. You can go back with the bailiff. Tyranny Thomas.
I think it's Tyranny.
Tyranny
Female.
Thomas.
Female.
Good morning. Is it Tyranny?
Tyranny.
Tyranny.
Yes, ma'am.
You're Tyranny Thomas?
Yes, ma'am.
And this is cause number 13-18010. And Mr. Parker, will your client waive the formal reading of the motion?
She will, Your Honor.
So the motion was filed back in 2018?
Yes, sir. Yes.
Ms. Thomas, I have a motion to revoke your unadjudicated probation. And it shows that you were placed on probation April 25th of 2016 for the offense of forgery. And that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department August 20th, August 28th, September 13th, and October 10th of 2018. Is that true or not true?
It's true.
And then count 2 alleges that you failed to provide verification of performing the community service hours as directed. And is that true or not true?
True.
And then count 3 alleges that you are behind in your court-assessed fees. And is that true or not true?
It's true.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker?
I did.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison. So it means as long as I give you 5 years or less, if I revoke your probation, then you can't appeal that decision. Do you understand? State tenders number 1,
No objection.
it's admitted. Is there any evidence Ms. Thomas is not competent?
No, Your Honor.
All right, ma'am, I'm going to find
This is the most sobering moment of the hearing. 7 years gone, 0 reporting, and now the court hits pause, not mercy, not punishment, but uncertainty. No bond means custody. Stays in place while the system digs deeper. Deferred probation can feel invisible until it snaps back years later. Let me ask you, should long dormant cases still carry this much power? Or is this accountability long overdue?
that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that the probation department can do an updated report. That'll give me more information about what's been going on, your probation, and then we'll come back at a later date for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker, and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Thank you, Judge. Oh, Judge.
Yes.
She's on deferred and does not have a bond. I told her I would request a bond. She has the ability to get back to work. She's been working and
I'm helped in LA right now, so I'm just trying to get back to work. I work at a nursing home.
Well, you've been gone for 7 years, and so I don't know what's been going on for those 7 years since you've been on deferred probation. Starting in 2016, it looks like you stopped reporting in 2018.
Yes, ma'am.
Based on that, and based on the fact that I have no other evidence at this time, I am going to find that it is in the best interest of society and our community at this time that I not set a bond in your case. Let's get the updated pre-sentence report. I want the probation department to be able to look into what's been going on, and then we'll see what happens at the next court date.
thank you, Judge.
Go back with the